Okay, good morning. Oh, sorry. Good morning, everybody. This is Lou Farina from the SBDC, the Maricopa SBDC. And we're here today for a terrific webinar being delivered by our partners at the USPTO. We're going to talk about patents. We're going to do a fairly deep dive. This is part of our COVID-19 trading series. Again, for those of you who don't know me, I'm Lou Farina. I am the business analyst here at the Maricopa Center who works primarily on technology commercialization, which is a term for all things technology, intellectual property included as part of your business strategy process. Today, we're going to talk about patents. We're going to talk about types of patents. We're going to talk about the application process, parts of the application, the examination process, office actions, claims, and analysis with respect to novelty and obviousness. And those are all kind of legal terms to a certain extent for working with patents. Before I introduce our guest speaker, let me just tell you a little bit more about the SBDC. This is our 1-minute infomercial. So we're part of the America's SBDC network. America's SBDC network is a nationwide network of organizations who provide business assistance to businesses in all stages of their business. We are no fee service, prepaid by your tax dollars, and primarily what we do is counseling, which is one-on-one engagement with clients to work with them on their business. They're usually long-term engagements for our successful clients. We do some training, and this is part of our training series. We've got resources and tools that are no fee that are available to our clients. Areas that we specialize in, and again, we're gonna have to change the slide at some point. Disaster assistance is at the top. 2 years ago, it wasn't even on our slide. So we helped a lot of folks with their EIDL and PPP and other disaster assistance programs. But more traditionally, we do a lot of lender readiness. If you're going for a loan, you need help with an SBA loan package, we can help you with that. We can do financial analysis. We have marketing expertise, business, selling a business, manufacturing, technology commercialization, as I mentioned. We've got some specialized personnel in export international trade, and a specialized group in government contracting. So here's our website. Anybody who's in Maricopa, please feel free to contact us if you need some assistance. So I will turn it over now to Jeffrey Palinic. Did I get that right? All right, Jeffrey, thank you. He's the primary patent examiner and assistant outreach coordinator for the Western Region USPTO. I won't read his whole background, but looks like he's got deep experience in patents and patent examination. We're really lucky to have our USPTO partners and Jeffrey with us. We do a series over the year with intellectual property, patents, and next will be trademarks coming up in the fall. So Jeffrey, I will hand it to you. I let you introduce yourself, and I'll let you share your slides. So here we go. Oh, wait, hang on. I'm sorry. Poll. I'm sorry. So we got a poll in here. I'm sorry. Eileen is in the background here. Can you run the poll? Is that okay? Our poll, if it pops up, we'll give her a minute, see if she can do it. Tell us about your business. Have you filed for a patent? Oh, yes. Oh, she said, give me a second. We'll give her 1 second. And all this is going to do is let Jeffrey know. Oh, we cannot do the poll. Okay, pass it. Okay, sorry about that. Let me give Jeffrey. Can you? I'm going to stop sharing, and you have the ability to share.
Do you want to continue? Yes, it looks like it's given me the ability to share, and
Perfect.
You should be seeing hopefully a single slide.
I see it. Perfect.
Okay, one slide. Okay, great. Well, as Lou mentioned, my name is Jeffrey Palinic. I'm a primary patent examiner with the United States Patent and Trademark Office and have been so for the last 15. I've been with the office for 15 years. With that, I've been a primary for a little over half that, or about half of that. And my primary focus is in organic chemistry, pharmaceuticals, cosmetics. Goes on or in the body. I'm probably going to take a look at it. Um, with regard to my extracurriculars at the office, I have had the very good fortune of being able to serve on this detail as an outreach advisor, which is basically enables me to get in touch with the public, have a more public facing aspect of to my job, and get in touch with the people that actually filed the applications and hear all their feedback, good, bad, what can be improved, and so on. And to that point, we like to conduct and perform outreach in many ways in the form of presentations such as this one to, as the title suggests, demystify our system, give some give more highlights about the background, what goes on in the background, why is it important, and what options and are available to you, the inventor, or to give more clarity where questions are asked. I mean, it is a weighty process to file for a patent and to get a granted patent, and I appreciate the Lou. I do appreciate the aggressiveness of what we're the topics we're going to discuss today and touch on today. Arguably, each and every one of them could probably be their own 90-minute presentation unto themselves. But we'll get as deep today as we can, and of course, there are other avenues to get more information, other presentations, and other resources. We'll certainly cover those in the next several slides. So, without any further ado, let's just dive right in. So as this slide implies, intellectual property has been around for the longest time. People have had no shortage of ideas over the totality of time. Let's just say, I mean, obviously back to the invention of the wheel, but it's more recently, I guess you could say, since 1787, excuse me, been codified in our own uh, within the Constitution, that people will have the rights to their ideas and they will be able to exclude others from being able to use those ideas that they claim property to. And to that extent, the the U.S. intellectual property, the manner in which intellectual property is delineated is it comes in several forms. There's patents, of course, what we're going to discuss today, trademarks, as Lou alluded to earlier, and then there's also copyrights and trade secrets, neither of which we're going to discuss in depth beyond mentioning today. But just so you understand that you have, from a fundamental intellectual property basis, you have different ways to secure your intellectual property depending on what that idea is and what sort of protection that you are looking to seek. So today we are going to focus on patents, and what patents are empirically are is the fundamental right to exclude others from making, using, selling, offering for sale, or importing your claimed invention. Basically, what a patent is the one and only legal monopoly within this country that is codified in the US Constitution, basically saying that with regards to patents specifically, for a period of time, and in exchange for full disclosure of what your invention is, we will grant you the right to use that property as you will. So patents are at their root a form of property. They are intellectual property, unlike tangible property, say like a house or a car. They are your idea that can, I guess, ultimately take the form of a tangible piece of property, but they are your bit of property to use as you will. You can use it to found your business. You can, or as the basis to pursue financial support for your business. You can license it to another person to make and use as they would see fit for in exchange for whatever you agree to within that agreement, that licensing agreement. You can flat out sell it as though it were a piece of property. I offer, for example, IBM. IBM, as part of their assets and um, their as part of their asset sheet, probably keep a long list of those inventions that they develop but never bring to market. They just, we can license that, we can sell that. They are bits of pieces of property to be used as you see fit, as in that respect. So in terms of the types of patents that we have to offer, there are three kinds. There are utility, design, and plant patents. So ideal in utility patents, which, so from our discussion about patents today, it's going to be very utility centric. Design patents and plant patents, since I'm biased towards utility, design and plant patents are what I like to dub the pretty patents. Designs are focused on a picture, the ornamentality of something. It doesn't have anything to do with the functionality of what you see in that design patent. It is just focused on the unique appearance of that patent. Plant patents as well focus on the unique appearance of a plant that is made by the hand of man. And that's a critical aspect to think about when you are pursuing intellectual property. In particularly where it pertains to plant patents and utility patents, the hand of man, as we say, needs to be involved, because one of the founding ideas under 35 USC 101 is that inventions that are sought to be protected cannot include naturally occurring products. So plant patents in that respect are plants that have been formed, typically hybrid plants, and they typically have a very particular appearance to them. Fun fact about plant patents, they are the only patents that are published in color. Oftentimes because the critical feature, their novelty resides in their appearance. So okay. One other aspect I'd like to point out about patents is that the different types of patents, utility, design, and plant patents, all have different limited periods of time over which they offer protection. Utility patents are 20 years from the date of from the effective filing date, while design patents are 15 years. I believe plant patents are also 20 years. Don't quote me on that. If that is if that is an actual concern, I can get that information for you and I can let you know. But I can tell you design are 15, utility 20. Okay, so USPTO, we function as America's Innovation Society. Obviously, we operate under the umbrella of the Department of Commerce, and towards that end, the USPTO, through its review and granting of allowable subject matter in the applications that are filed before it, seek to drive commerce. We look to offer high quality patents that are, technically and technologically novel. They are not obvious over the totality of the creations and technology that have preceded them. So the patents, so in the utility space, the two pillars that we look for in terms of granting a high quality patent is, has it ever been done before, i.e. is it novel or non-obvious? And two, if it has been, if it's close to something that has been done before, going back to that non-obvious mention, is it something that has been improved upon? So, just because something has been created does not preclude it from the ability of having it be improved. Is there some unappreciated or some unresolved discovery that has just not been made with regard to the invention that is already out there? So in so doing, when we allow these brand new patents, these high quality patents, these highly scrutinized applications out the door, we are looking to drive commerce by bringing to the public that which has not been done before. So why is your invention going to matter? What are these inventions going to mean to you? So as translating over to the creation of a business, and I kind of mentioned this before, patents function as a piece of property. They can allow you to, as I mentioned, exclude your competitor from making and using the invention that upon which your business might be founded. So to that end, if it's critical that your competitor stay in competition with you, that's going to force them ultimately to try to invent around you or improve upon or get around what you're trying to do. It's going to force your competitor to pivot in a way that to succeed in an area that you're not. So it helps you take your space in the professional world. It helps companies grow, obviously, for obvious reasons. As I mentioned before, the patents function as a commodity upon which you can seek funding for your businesses. Um, a lot of times, venture capitalists will um, be more apt to invest in companies that have a solid grounding in the intellectual property upon which they're looking to base their business. Um, Obviously, more money comes in the door. It allows you to grow your business. It allows you to provide more jobs. It allows you to offer higher pay to your employees, attract more qualified employees, offer more benefits to your employees. It ultimately can result in you, if you can grow your business on the basis of this, it can ultimately offer you more leverage to bring in better, attract better, or more educated um, employees, offer them better uh, um, benefits to staying with the company. So um, there are a lot of incentives. I see that these are all referenced. I believe these are referenced from a IP in the U.S. economy report, which was originally published in 2015. And I believe there was uh, uh, an update to that study. Julie, if we have that link to that original report, as well as I believe is the 2019 update, if we've got that, if that would be of interest to them in the chat. Those will reflect on a lot of the points that I was just making, particularly with patents in the um, statistics for companies that are backed by IP. So pivoting pretty hard. Like I said, we've got quite a few topics to cover here. So moving from the way that a patent can improve, let's actually start looking at a patent. So a patent is going to have a lot of moving parts to it. This is the cover of a published patent. Obviously, there are a lot of important aspects on here that myself, my colleagues as patent examiners look to, particularly when we're reviewing brand new applications. But for your benefit, some of the ideas that we have on here, or some of the aspects that we have on here, are you have your U.S. patent identifier number, the date it was published, or the date of the patent. It'll have your inventive, as we call your inventive entity, the people responsible for creating the patent. It will also have the company that oversaw that patent, the title of your invention, when you filed it, any sort of priority that you have, meaning what sort of additional potential protection do you have with respect to your patent. Um, you'll see the tab there for prior art. Those are typically documents, and we'll get into that in a few slides here. Those are documents that were considered in weighing against what has been done prior to. That's why we call it prior art. Art is what we colloquially refer to as any form of documentation that has the potential to read on your application. And if those documents are listed on the face of your patent, oftentimes inventors like to cite these on the cover of their patent to show this is the totality, or these are the most critical documents that were considered leading up to the issuance of this patent. Um, Oftentimes people like to inventors like to place a drawing on the cover of their patent. That is certainly an option. It does not need to be there. Oftentimes the drawing that does appear on the cover of a patent is most closely reflects what the actual invention is. Um, we also have an abstract. I like to analogize patents to novels and cliff notes. If you go back to a book that's got a dust jacket on it, the abstract is going to be, if you open the cover of that book, you're just going to peruse that really brief description of what that story is, just to see if this is something that you're interested in continuing and reading further. Such is the way of any abstract, really. The claims are what I refer to as, say, like the cliff notes. It covers the very critical parts of what the story is about. It covers the claim in this, analogously, the claims cover the very important um, as we call the meets and bounds of what the invention is meant to cover. Those four corners of the invention that are this belongs to these inventors. The specification, on the other hand, is the novel itself. It is the totality of all the definitions, all the story, all the everything, the examples, closest to what you're claiming. Uh, Also, other ideas that are there for potential other inventions. Every last little detail that is important to defining what is set forth in the claims. Okay, so we do have here a sample claim. So claim language, when I give presentations on how to construct claims or what is involved in claims, I often lead off with the fact that claims are single sentence, and they're going to make any grammar teacher go screaming into the night simply because they are one sentence. It is probably the worst sentence that you're ever going to see. It is the ultimate run-on sentence that talks about what is going to be in this patent. And to how can I say this? So there are two types of claims. There are independent claims, and then there are dependent claims. So an independent claim is going to cover as much as possible about the invention without getting too terribly narrow, but because a claim that's too narrow has the potential to be of little value, just because if it's so narrow, it's not going to be hard for that competitor of yours to invent around. It's going to be very specific. Whereas if the claim is too broad, it's going to be the likelihood of that claim being read on by things that are not necessarily within your scope of what you consider to be in your invention increases drastically. So there's really kind of a sweet spot between too narrow and too broad that you want to focus your claim on. So this is a general just a simple claim directed to a chair. It contains three parts: a preamble, a transitional phrase, and then, as we say, a body to the claim. So the preamble to this claim is a chair. Uh, so inventions in the utility space will be either a composition, a method of making a composition, an apparatus, or a method of using a composition. In this case, this would be couched. This would be under the umbrella of a composition. So in this case, the preamble is directed to a chair. Our transitional phrase here is comprising. Now, a transitional phrase is meant to convey the scope of the overall invention. So in this case, we have comprising, which is this is the most open scoped transitional phrase that we have. So comprising essentially means that it has to have these components, but does not exclude anything else from being included within this invention. Now, if this claim were to say a chair consisting of a seat, a back, a support, a base, that means that this claim will have those four elements and nothing else to it. Consisting of is our most closed transitional phrase, and it meant to be very specific. There is a third transitional phrase that we use, and it's consisting essentially of. It has a little bit more granularity to it. Basically, what's the best way to say it? It's consisting essentially of. It will have these elements, so it's very close to comprising, but as long as it doesn't have anything else that materially impacts the invention, it can be included. If it materially impacts the invention, then it then then what that element is that is present in the art will actually keep that art from reading on the claimed invention. It's a very tricky phrase to use and oftentimes gets used improperly. Most often we try to guide applicants to claiming their invention within comprising or consisting of space. And another thing about transitional phrases is that throughout the body of the claim, you can use combinations of them. You want to be careful how you use them, but you can use combinations of them. So going back to this very more simple claim, we have a chair that comprises a seat, a back, a support arms, and a base comprising a plurality of legs attached to the seat. So as you can see, we can have multiple We can have multiple phrases within the body of the claim itself. So the body of the claim are those positively recited elements, as we say, that define what that share must minimally contain. So as you can see, any one of these topics we can spend a whole quality amount of time on. Okay, let's keep this moving. So who can be an inventor? Perfectly honestly, I think the youngest inventor I have seen, and I'm blanking on her name, is the inventor of the I'm going to call it the puppy puffer, but totally I'm totally misnaming that invention. She was 9 years old, and it's on our website. She invented basically a jacket that she could put around her dog and attach a vacuum device to it so that she could dry her pet without and keep him far more calm instead of just blowing on him with the vacuum cleaner. I'm so sorry, I'm blanking on what that invention is called, Julie. If you could put a link to that in the chat as well. But the short version of that story is that there's really truly no age limit to how young or how old an inventor can be. Anyone who contributes to the conception of an invention, even beyond their life. I have actually had applications where one or more of the inventors is no longer with us. So as long as their name is on that patent as an inventive entity, alone or in combination with others, they are still considered to be the inventor on a patent. So, all right, so let's get into the journey of a patent, the application journey. It's delineated here in 4 steps. It involves a lot more steps than this, but for the purposes of today's discussion, we're going to break this down into the 4. So first, of course, you need to have an idea. And is that idea worth protecting? Whether or not it's worth protecting, that's going to be something that is going to be a decision unto yourself. We don't provide feedback in terms of is something worth your time. Our burden is to simply take the inventions that are brought before us and evaluate them, as I said, against the totality of the relevant technology that has preceded it. So first of all, have an idea. So is your idea going to be eligible for protection? So these next couple of slides are going to talk about a few of the statutes, 35 USC 101, 102, and 103. And these are concepts that I've mentioned already here. So first of all, under the 101 statute, is your idea eligible for protection? As I said, it's got to be a composition of matter, a method of manufacture, a device or apparatus, or a process for using that invention. And going back to my earlier mention of planned patents and involving the hand of man, there are types of inventions that are certainly not eligible for patent protection, and those involve ideas of natural products or natural phenomenon. So you cannot get a patent for gravity. You can't get a patent for something that reads on, for example, anything of nature. You're not ever going to get patent for water. Also, you're not going to get things that oftentimes involve mathematical equations or natural phenomena or theoretical inventions. So time travel is never going to be a patented invention, at least as far as I know. It's not going to be a patented invention. Perpetual motion machines, things that are completely theoretical or cannot be, delineated within an application. So in my particular technology, I don't get a whole lot of question as to whether or not something qualifies as being eligible for protection. The way something is claimed oftentimes puts it in the space where it will be eligible for protection. Statutes 102 and 103 respectively are directed towards the novelty and non-obviousness of a particular invention. You see the pictures here of the weed whacker and those various forms of string trimmers that have come before. If you're the first person to ever have invented the weed whacker, then your invention at that time would have been considered novel because it would have never done before. A lot of times I have colleagues who are in the chemical arts, i.e. they look at applications that are directed to brand new chemical compositions that have never been created. So if it has never been created before, we say it is novel. In terms of non-obvious, I more colloquially call this the duh art, the duh um, type of approach, just because how many times have you asked yourself, like, man, I totally could have come up with that idea. That idea just completely makes sense to me. That doesn't seem like it's new to me, because I mean, why didn't you just tweak this element and just do this? From our perspective, that is what we categorize as being non-obvious. So as I mentioned, a lot has been done in the history of technology, various different technologies. So if there is an argument that we as patent examiners can raise in terms of, if I take this and take this, would it have been obvious to make this new idea? That's the type of argument that you might see from us. It doesn't mean that that type of argument is insurmountable. It just means that this is the issue that we're putting before you. Tell us why we are wrong, or tell us why this is not obvious. So you've heard me mention it several times before at this point. What is prior art? Prior art, as you know, very broadly speaking, is the totality, represents the totality of technology and publications that has come before the application that you have filed. Now that can occur in any sort of medium, as long as it has a date that we can label to it, that we can assign to it when it became available to the public. That is the linchpin argument about prior art. It has to be available to the public, and we have to be able to show when it was made public. Prior art can occur in the form of patents, printed patent applications, printed publications, any form of disclosure available in some sort of medium. It can be a video. I have actually personally used Facebook postings as prior art. It can be a YouTube video, as long as it occurs before before an application has been filed before the office. It is potentially eligible. Now, there are some windows of time that play into that decision, but on the whole, prior art is any form of publication that comes before an application that has been filed and potentially reads on that claimed invention. Okay. Step 2 in our journey here talks about presenting your idea and maintaining confidentiality. Now, this slide is going to be seemingly a little contradictory. So, in presenting your idea, one of the concepts that we like to approach about your idea is, what do you say and when do you say it? We call that the risk of early disclosure. So, obviously, if it's a brand new idea, you're trying to drum up your business, you're trying to grow your business. Who do you, what do you say and to whom? Do you go out and just have a poster presentation? Do you try to generate crowdfunding? Um, do you draft up an NDA and approach an attorney about how best to do this? That is your decision and your decision alone. How best to protect your idea without giving away the entirety of your idea, because until you get that application on file with the patent office, you really don't have any protection other than just keeping it a secret to yourself, keeping it close to the vest, just you know just telling people what you feel they need to know about it without telling the totality of the idea. It is really a total judgment call. But in that whole nugget of suggestions right there, what I do want to impress upon you is that once you file that application, the before the patent office, the ideas and the concepts and the definitions and everything that you are describing as your invention then has what we call an effective file date, because the U.S. Patent Office, with the rest of the world finally, now operates on a first to invent, a first to file. It's a first to file system. If you and your colleague are racing to the front door of the patent office to get your application filed, the first person to that finish line gets the benefit of having that first filing date. So when you're approaching people about your idea, presenting your idea, tell people exactly what you feel they need to know, but be guarded about what you tell people, because people, it's been done before, which is why we talk about it. People will have been known to swipe other people's ideas. And the last thing you want to have done when you're trying to grow your business as a brand new business is to have someone sweep the rug out from underneath you and um, ruin your chances at securing that particular intellectual property. So one of the best paths forward is to just keep it a secret. That also kind of toes the line of it becoming a trade secret, but you can go that way and disseminate it as you will. Um, you can consult with an attorney about best ways to disclose that. We don't recommend that you consult an attorney. That's tantamount to legal advice, but just so you know, it is an option. And I think, as I understand, most attorneys, since they're bound by, um, you know, like attorney-client privilege, and most attorneys might push back, as I understand, they might push back on having signing an NDA, but just because it's basically their livelihood that they're gambling with if they're going to try and steal an idea in that fashion. But they are typically a safe space to consult your ideas, much in the same way we are also a safe space to um, consult with your ideas if you want to have a one-on-one consult with us. Part of our mandate with the regional offices is to conduct one-on-one consults if you have specific questions, particularly if they go beyond what we're talking about here today, and we'll re-impress that point later on. So again, don't be afraid to reach out to us. We are also bound by the law to not be able to actually file for applications while we work and practice before the office. So uh, our next step is drafting the application. So we're kind of skipping through some of these high points. So the third step is we're going to now prepare this application and we're going to file it before the office for consideration by someone like myself. So what do I need to disclose? Why do I need to disclose? I think is a better way to pose this question. A patent, as I mentioned before, is the only legal is the only legal quid pro quo in the land. So going back to what I said about what defines a patent is a legal exchange. You, as the inventor, provide full disclosure of what your invention is to the public in exchange for that period of time at exclusivity and owning that invention. So the right to, again, the right to exclude others from making, using, etc., your invention for a limited period of time. So the exchange is that you fully disclose. So you have to be able to tell others how to make, use, and so on with your invention, but they cannot do it without your permission. So what do you need to disclose? So going back to the parts of the invention that we discussed earlier, so there is a specification. And as I mentioned before, it is the longest part of a given, any application. Odds are it's going to be the longest part of the application. So within the confines of that specification, um, you are going to, as we said before, and within the bounds of the statute 35 USC 112, you are going to provide a written description of what your invention is. You are going to provide description enough that will enable a person associated with that particular technology or art, as we call it, to make and use your invention. They have to be able, much like a peer review journal, it has to be reproducible. The invention has to be reproducible in order to have value. If you're not public, if the public disclosure of your invention does not allow it, then what we will provide then is a showing that on our end that your invention is not necessarily enabled. Excuse me. And then lastly, the best mode. Um, the best way to the best way to contemplate it to accomplish this invention. So each of these, and I'll mention this later, we as examiners raise what we call objections to, or rejections to different applications. So each of these bullet points represents a different type of rejection. So we can, if something is not described or placed within the purview of the skilled artisan to the public, we say that you're failing to make a written description. You're failing to describe your invention. If we make a determination that someone it's not clear what this invention is on the basis of, well, it's going to, there's way too much research, there's way too many questions, then we make the allegation that, or make the rejection that your invention is not enabled. It is a very high bar to demonstrate that someone is not describing the best way possible to carry out their claimed invention. So towards that end, we really don't usually raise that as an issue, but it is one prong of providing full disclosure of what your invention is that does need to be provided in exchange for that protection. And oftentimes too, that is carried out, that's shown in examples or embodiments that appear within the specification. And then going back to the claims, are the claims clear enough? Do they provide definition enough so that people of skill in the art, again, can determine what are the boundaries of the invention that you are seeking protection, for which you're seeking protection? So as long as the claims are clear, they use language that finds support within the specification. They use jargon that is associated with the technology and has definition within the specification, and I, as the examiner, can make heads or tails of what you are claiming as your invention, then clarity of the invention is present. All right, lastly, you filed your application. The application is on file with the USPTO. You will file along with that a ton of other paperwork, including fees, one of which is a sworn oath and declaration that you invented the invention that is so forth described. That goes so far as to establish what, as I mentioned before, what that inventive entity is. And each of your inventors that are listed on the patent will have to be listed on the oath and declaration and will sign attesting to these statements as well. So I mentioned fees. We have, if only our fee chart was this small, we actually have quite the lengthy fee schedule. And what you will notice about this fee schedule right from the off is that we have 3 different status types. We have a large entity, small entity, and micro entity. So your large entities are obviously, they're going to be your IBMs, your Abbott Labs, your L'Oreal's. They will pay whatever our full price is, they will pay that price. A small entity is defined as being a company that is 500 people or less. I believe there's some other criteria that go along with that. Most small businesses qualify as small entities, but our immediate qualifier goes by the number of people employed by the company. So I believe if it's 500 people or less, you qualify as a small entity, and those fees are 50% off of our normal fees. And then lastly, micro entity fees provide a 75% discount on all fees with an income threshold of a little over $200,000 per year for that person. And oftentimes micro entities are going to be directed towards the single inventor, the first time inventor, those inventors who have not filed more than 4 applications before the office on their own. And if they are part of, let's say for the sake of example, this single inventor works for a small entity and his name appears on a patent filed by that small company, that him being associated with that patent will not count against him, or her, excuse me, will not count against them if they're looking to file an application as a micro entity. One additional thing to observe about this table is that these are just simply our fees. This does not take into account any sort of attorney fees whatsoever. Seeking out an attorney is something, again, we don't provide advice on it. We do provide resources to help you conduct that search. We do on our website maintain a list of attorneys that are licensed to practice before the office who are in good standing. We also actually provide a naughty list version of that as well, who are registered before the office but have also been reprimanded by the office. Since if you are going to go down the road of seeking out an attorney, we want to provide you with the best information possible. So we are those lists also allow you to filter what attorneys technology by region, as well as whether or not they've been reprimanded. You're going to be working with this person for conceivably a long period of time. You want to do your research, and if you're going to pursue an attorney, you want to have a good working relationship with that person. Path to the path to a patent, the patent application roadmap. This accurately, this is pretty good in terms of the different directions of a given patent application can go. As an examiner, I have had applications that have gone straight to being allowed as patents, but I'd say more in the mid to low 90s percentage of the time, a given application is going to receive written objections and or rejections by the examiner to whom they're assigned. So the way it works is it's an exchange, it's a negotiating period. Simply because your first pass at a set of claims isn't accepted or it gets a rejection, um, it's not the end of the world. Quite honestly, it opens up the period of negotiation to get your invention. If you guys are starting here, but we're arguing that it should be here, obviously there's wiggle room going back to that virtual triangle of scope that I was referring to earlier. Patent examination is simply us providing you a showing of what has been done prior to your application, and initiating that period of negotiation was like, okay, well, if it's going to be too broad, let's try and narrow it down more closely to what you did, but so that it reads away from other things that have been done before. And that's why the figure eight in the middle. So it's meant to be an exchange. So you file your application, we research your patent application, we provide you references and reasons for why at this time your application is not allowable. We send that out in the form of a written opinion. We call them rejections. I don't like that term and never have. They are basically our opinion as to why your invention is not patentable. That opens up the door for you, the inventor, to provide us either with amendments to the claims, narrowing the claims, altering your invention, or arguments in response to our arguments as to why we are wrong. We're not right all the time. That's why we have allowances, because sometimes we are the patent office. We're not the rejection office. Um, so back and forth through the figure eight we can go. And ultimately, the ideal outcome is that we negotiate to a point where you have an allowable subject matter. There are unfortunately other modes of disposal. If, for example, we between the inventor and the examiner we cannot agree, there is a route for you, the applicant, um, to have a higher form of opinion review the case, and that is the path to appeal. At which point you, the applicant, become the affiant, or the appellant, excuse me. Uh, you will file a brief to be considered by the examiner and his supervisor, and in some cases a quality assurance specialist or QAS. And if the determination is that the examiner's position is sound, then it will proceed to the Board of Patent Appeals and Interferences for a higher decision. Another route is that maybe the examiner's supervisor and that quality specialist say, no, you know what, the examiner's wrong, this doesn't even need to go to appeal. Sometimes, not often, but sometimes that application can be reopened and the examiner has to start over. And then of course there is also the other outcome, abandonment. So if for some reason you fail to meet a deadline or fees aren't paid in the proper amount of time, ultimately what can happen if the case goes unaddressed is that the case is just simply abandoned. So, as I've been kind of alluding to with different aspects of what we do as patent examiners to evaluate an application that's coming in, kind of touch on the role of what the examiner is here. So, as I've kind of alluded to already, we take in the application. Once the application is docketed to an examiner in the relevant technology, we look to read and understand the application. We don't read it cover to cover. Um, to be perfectly honest, I don't know that a given examiner would agree that they have the time to read it as though it were a novel. But as an examiner, personally, I start out with reading your claims. I look to see what it is exactly that you are trying to invent. Since I'm pretty well steeped in my given technology, I can start out by reading the claims and have a fairly good idea of what it is that you're going to pursue. If I have any questions, I can evaluate those claims within the guide using the guidance provided in your specification, or at least try to. And again, that's premised on the fact that you've provided me everything, all the back information that I need to rely upon within the specification. And a lot of times I do end up relying on the specification to get additional clarity, to get additional, structural relationship between components and how they're put together. Um, so we use the totality of the resources at our disposal to evaluate your application. We consult various different searching resources, everything from the internet all the way up to proprietary software that has been provided to the examining core to evaluate inventions, peer review journals, social media. If it's out there, it's at our disposal. And again, as long as we can assign a date to it, demonstrate that this was available at such and such a time. Then we offer our written opinions in the form of office actions, and if need be, we hold interviews. Um, in fact, I just had an interview this morning during which one of the big things that we try to do with an interview is to just skip ahead to this one here. So one of the points of the interview, and it is a very powerful tool that most people don't necessarily um, don't use probably nearly as often as they realize that they can. The point of an interview is to get the attorney, and in many cases the attorney with their client in front of the examiner to um, talk through a stalemate. A lot of times, in fact, the case that I just just interviewed this morning, the attorney and I, going into that interview, were at a conceptual stalemate. But through that discussion, the back and forth, this is why we're doing this. This is so if you consider it from this point, this is what we're doing. Oftentimes, that can result in just the light bulb popping on for the examiner, saying, "You know what? That's a really interesting point. That to me shows critical evidence that could at least move us past the reference that we're arguing over. You absolutely should make mention of that in your next response. You absolutely should make that amendment to your claim." Those aha moments is what the interview has the power to bring to light. And if you and your clients or your applicants are not embracing that tool, you absolutely should. Examiners are supposed to grant interviews. Um, when requested, unless there is a real reason why those interviews shouldn't be granted. More often than not, your interview request should be accepted. Um, couple more points about the examination process. A rejection, as I said, rejection is not the end of the world. A rejection is just simply meant to highlight the art that is out there and that is known. It's to get the discussion off and running. So this is why it's not patentable today. Let's try again and allow you to change a few things, allow you to put a few arguments on the record to see maybe the examiner's position can be changed. And a lot of times objections and rejections can be overcome by one of either of those two ways, either argument or amendment. If you receive, like I said, if you receive a rejection, don't give up. As I mentioned before, very few applications go straight through to allowable subject matter. A lot of those times, they're either they're partaking in one of our accelerated prosecution programs, such as Track One or Patent Prosecution Highway, which requires you. There's a fee involved, of course, but requires you to provide the office with a far more focused application, and they also get priority in examination. Um, so yeah, a lot of our first time applications first pass through, a lot of times they are going to receive a rejection of some kind, not for the sake of rejection, but just because you have to start someplace. And let's get the idea out there, let's get it reviewed, and let's see what's out there. So going back to our diagram right here quickly, as I mentioned, this figure 8, so it's meant to convey you file, then we respond, then you respond. So one full circle of response. So I write, you write, then you get another bite at the apple, and then I will reevaluate that response. That exchange, that pair of exchanges represents what we call a round of prosecution. So once I issue what we call a final rejection, prosecution for that round is closed. Again, not the end of the story. We have several means available for the applicant to continue their prosecution. You can either file a request to continue examination, or an RCE as we call. There's also the appeal process, as I mentioned earlier. There's also a space that we call after final practice, and it gives your applicant the chance to make another argument, provide additional amendments, and file it outside the realm of the round of prosecution. And those are a type of response that will get docketed to your examiner, and they have a truncated amount of time within which to consider it. Now, the after final response can just be just that. It can be a response with proposed amendments and remarks. The examiner must consider it. There is another version of after final practice that we call after final consideration practice. It was no longer a pilot program, but what it does is it has a few more strenuous guidelines, particularly narrowing of the independent claim to something that is beyond what was considered previously. But it allows the examiner to have a couple extra hours to search that amended invention, and to also raise the potential to conduct an interview to help focus that invention. The idea being that the examiner has a little bit more time to consider this slightly amended invention. Does this put the invention in consideration for allowance? The idea being to just give one more last bit of consideration before going through the rather expensive process of filing a request for continued examination. It is not, I will be honest about that. I think for large companies, it's like $1,800 to file an RCE per case, per round. So the idea is that we save you, the applicant, some sort of money by giving a little bit of a time and a little bit of extra consideration outside the process. I will admit this slide is not wholly up to date. The critical element of the processing timeline is this first amount of time leading up to when that application, between which the application has been filed and when the examiner picks it up for the first time. So this slide says about a little over 14 and a half months. I think currently we're somewhere up to, I want to say like 18 and change months. So, I mean, with COVID and everything, people got pretty creative and pretty inventive. I think trademarks outdid us with the number of filed applications. I think they're probably a little bit more simple to file. But with patent applications, we definitely had an uptick in filings during COVID, and so there is a bit of a backlog that examiners are working through. So I think our processing time is a little bit elevated at the moment, but typically that is the longest, consistent with this chart, that is the longest period of time between when you file and when when your application is picked up for consideration for first action on the merits. After that, once we have considered it, once we've sent something out, timelines are imposed upon every part of the process, and it's meant to get it through the process and on their way to some manner of disposal, ideally allowance and issue. So as I said, after all the back and forth and after all the negotiation, if we can get you down to what you claiming what you did or some manner of allowable subject matter, that's the point at which we issue a US patent. So the key point to the entirety of this process, and I probably should have led off with this, is to remain engaged through the entirety of the process. It is a long road. I will not kid you about that. It can be a very long road. It can be a very short road. Depending on one of the hallmark statements that we say probably every pay period is, if it depends, or each case on its own merits. Each case on its own merits rings very true because different technologies move at different speeds of examination consideration. They have their own different forms of resources of prior art to rely upon. And a case filed in the organic chemistry art units will move through differently than one that is probably filed within the computer art units. So. All right. Lastly, we have a variety of resources. This first slide, obviously, map of us. the colorimetric breakdown of the different regions within our country. Again, I mentioned I'm currently serving with the San Jose office, which is in California, Silicon Valley, aka the Western Regional Office. We cover every state that touches the Pacific, including Nevada, and in addition to Nevada and Arizona. The Rocky Mountain region, listed shown in purple, covers the 9-state donut that surrounds Wyoming. There is a 9-state region that covers all the states that form the donut around Wyoming. We have the Midwest. We have the Eastern Region office that can the entire eastern seaboard, including Puerto Rico, and then the Texas region. So each of the given regions has a regional office to which you can turn for assistance. And just because you live outside one of the regions does not mean you cannot turn to one of them. We are here for you. Access our free services. So if you go to, that is the direct link to this webpage. If you follow that link, you will see these 4 icons. These icons on this page are meant to filter down the different types of services that you're looking. So if you're looking for all the services that pertain to patents, you can just click on that link and it will pare them down. If you go to our main website, uspto.gov, you can do, if you don't see it right away, just do a quick word search for access our free services. Literally, it will show you where that link is on the page and you can click it. It will take you there. Long and the short of it is it takes you to an entire menu of resources that we have and the links to those pages. One of the most critical ones is the Inventor Assistance Center. So likely you will have questions when you can't get a hold of, if you can't get a hold of your examiner, or if you can't get a hold of someone at the Office of the Inventors Assistance Center is on service, is serviced, by former supervisory patent examiners, retired primary examiners, to be available to answer your general questions. They cannot do the work for you. They cannot fill out forms for you. They cannot respond to rejections for you, but they are there to help you with generic questions about examining patent policy and procedure. One of the absolutely most useful services are the patent pro bono program. We realize and recognize that the filing of patent applications is a very expensive endeavor. Even if you're doing it as a micro entity, it can eventually become very expensive process. So to that end, we do provide resources directing you to various patent pro bono programs throughout the country. And with Arizona, the Arizona Public Patent Program, I believe is run out of it's not in the notes in these slides, so I am blanking. I want to say the patent pro bono program, I might be confusing it with the law school clinic, is run out of Arizona State University. Don't quote me on that. If you do follow the pages if you do follow our free services to the pro bono program and isolate it by state, that our webpage does provide links from the pictures that will enable you to, it will direct you likely to a third-party site that will take you to that patent pro bono program. Law school clinics, as I alluded to, as I mentioned earlier, it's another form of patent pro bono program. It's not called pro bono outright, but essentially what the law school clinics and also law school certification programs, it will put you in contact with a law student who is currently in law school, and the benefit, it's somewhat of a symbiotic benefit that you get to work with a law student, I believe for free, and they will get the experience of working with a client and working in the intellectual property space, but you are not working unprotected. That student is working under the tutelage of a registered attorney. So you get the brain of the law student as well as the attorney that is mentoring that student. But if your state has has a participating law school, that is another resource that is at your fingertips. If you follow that link, there is, again, we love our maps. It'll provide a map that's similar to this one, and it will show you the different types of programs that are available throughout the continental U.S. and Hawaii, Alaska, and Puerto Rico. One disclaimer about that is not all law schools provide all the same services, so be very cautious about what schools provide. Some are patent only, some are patent and trademark, etc. And then lastly, our patent and trademark resource centers. We have the Arizona Library, State of Arizona Research Library houses in Phoenix, houses our one and only Arizona PTRC. Basically, what the PTRCs are, they are essentially libraries that are staffed by trained librarians to be able to provide you the resources that you have, that we as examiners use. So at each of the regional offices, we do have search facilities, and with those search facilities, you can come in and, just like a library, just like jump on one of our computers and start doing research using some of the tools that the examiners themselves have. The PTRCs are simply an extension of that. We realize everybody can't get to each and every one of our regional offices, so PTRCs are libraries oftentimes set up in either public libraries, university libraries, state libraries throughout the country, and are staffed by trained USPTO personnel. A couple of our quick resources with guides, direct links, our application guide, searching guide. Pro Se Assistance Center didn't have a slide unto itself, but if you are an inventor who wants to pursue patent application without using an attorney, there's nothing wrong with that. Just so you know, it is a very lengthy legal process. There are a lot of forms. We do provide information as to the pros and cons, as benefits of doing pro se. There might be a little bit of a cost break. On the other hand, if you do retain an attorney, keep in mind you are retaining that attorney and paying that attorney for the knowledge that they've learned and the knowledge that they have before with practicing before the office. So if you do decide to go the pro se or on your own, we do have a Pro Se Assistance Center, and we do have an art unit that is dedicated to handling pro se applications specifically. So that brings me to the end of my presentation. And it was a lot of talking, a lot of topics. As I mentioned, each and every one of them can be an hour presentation unto themselves. So yeah.
Jeffrey, so thank you very much. That was
Sure.
excellent. It was unique. I tell you, I've seen several of the USPTO different patent presentations, and I really liked your approach in getting into some of the detail about what the patent really includes. We did have a couple questions.
Absolutely.
Let me fire match. I don't know if you can see them. The first one is from Jerry, and has to do with ownership and passing down a patent. So if the inventor dies before the patent expires and there's no one else involved or on the patent, can someone else acquire it? Do the heirs become the owners? What happens if there are no heirs?
We, as the USPTO, as far as I know, will not become the owners of that patent. Ownership. You're familiar with the phrase "possession is 9/10 of the law." My guess is that the estate, again, my guess is that the estate of the inventor who has passed on will have seen to the possession of that invention. So if inventor A is working, a lot of times, if we go back, if I could show you that slide, again, the anatomy of a patent. Let me just reshare my screen here real quick. Come on, there we go. Sorry, take just a second. So, come on. Are you seeing the patent slide again?
Yes.
Okay. So if we go to this slide here, the anatomy of a patent, you on the left side, on the right side of the screen, under your name, you'll see the names of the inventors. And let's say, for the sake of argument, each of these inventors has now passed away before or even after the patent has been issued, but before the patent has expired. Who then would likely become the owner of that patent? Well, you also see in item 73 that this particular assignee is Disney Enterprises. So they are also today what we consider one of the inventors. So in all likelihood, in this particular case, let's say Mr. Hausman, Moore, and Carr, uh, inventors Hausman, Moore, and Carr have all passed away. Disney would, in all likelihood, become the sole owner of this patent. Um, Again, one very particular case, but if there is one inventor, let's say it's a pro se inventor, inventor A has started this process, it's on that inventive entity to make the arrangements of who's going to possess it and where that invention is going to be owned. My guess is that it would probably be part of that inventor's estate to be legally determined. So
Okay, great. I had one more question in
sure.
the chat. So, okay, I'm just going to read this one. I'm sure I understand it. If one has a non-patented product on the market currently
Mhm.
and now wants to patent it, how much has to change in order to file a patent on it? And what percentage of a current patented product can be duplicated to be considered infringement on a current patent? So it's two questions actually.
Mhm. All right, well, I'll tackle the first one first here. So if one has a non-patented product on the market currently and now wants to patent it, I'll go back to those two phrases we say just about every pay period. This alludes to the first one. It depends. So when evaluating prior art and evaluating a patent application, one of the going back to the the novelty versus non-obviousness. I mentioned that there are windows of time within which an examiner has to abide by in order to apply prior art. So once you have your application on file, that establishes what we call an effective filing date. So let's say for the sake of this argument, or the sake of this example, excuse me, that you got your application filed on May 5th, 2021. So what that means is let's just use today's date. You filed your application today, May 5th, 2022. That establishes today as your effective filing date. Now, in order to evaluate what has been done before, we have to where my search would begin is anything that was filed on or before May 4th, 2022. So that establishes a date the day before. Anything on or before that date is potentially eligible to read on your filed invention. Now, your example, if I've got this non-patented product that's on the market currently, that is one part. It depends because how long has it been on the market? If it's been on the market since say like 2018 and it's exactly what you're claiming, you're never going to get that patent. I rarely say never. I'm saying never. Just because we have what we call a 1 year grace period or 1 year in order uh, period in advance of your filed application during which something may or may not be established as a statutory bar. On bar, an on sale bar is one form of that. So if you are claiming exactly what your product is, then you're going to have to change something very drastically about it in order to have it read away from that and be different from what you've already got on the market. As I said, prior art is anything that represents what has been done ahead of what you've filed. And that can be in the form of patented documents, it can be in the form of products, social media, you name it. If we can find it in show when it was made available to the public, it's of potential. What percentage of the currently patented product can be duplicated to be considered infringement on that current patent? Okay, so in the example of this non-patented product, let's say you want to let's say we want to do this. So we say, okay, I've got this product. Um, darn it, it was on sale a year or more before when I filed for this application. Um, how much do I need to change? You need to change it enough and I can't assign a particular percentage to it, but you need to change it enough to show that it is not the same product. If there's something else if your product contains components A, B, C, and D, and that's what you've been selling all this time, please, I hope your application has the opportunity to include other elements such as E, F, and G, because if that's something that is critical to your invention, for example, and that appears in the claims of the invention, not just the totality of the invention itself, but finds its way to the claimed invention, then that's something that can possibly distinguish over your previously on sale product, because that was not included over here. That strikes at the novelty. Now, was it obvious to include those other elements? That's another question. And if you can show that it wasn't, then that's a path forward. I did have one other thing I did mention. So that 1 year period ahead of when you filed your invention. Now, the other side of that depends coin is, if you, let's say you just started selling your product that has A, B, C, and D in it 4 months before you filed your application. That product, it's on market, you've been selling it, it's the exact thing that you're claiming. The examiner will likely raise it as a rejection, saying, hey, this is already out there. But since it's within that 1 year period and it is your invention, you have the opportunity to come back and exclude that invention from being considered as being prior art over your filed invention. If somebody else entirely made it, it's a little bit more of a hurdle. It's a lot bit more of a hurdle to overcome. But if it's your own invention and it's on the market and publicly available only within that first year ahead of when you filed your invention, you have the opportunity to exclude that as usable prior art. So there are different paths for it. Like I'll say it again, we could spend gobs of time on any one of these topics. That's a particular one of interest that we tend to do. So towards that end, I'm going to provide you with a shameless plug to attend our Path to a Patent series. We are in the middle of the current cycle. It's an eight presentation series that goes soup to nuts. It covers far more detail what we are talking about here today, but it takes you through the totality of the process: filing, the different types of applications, searching, application drafting, claim drafting, post allowance, things that you should be aware of, all manner of the patent process, far more in depth than what we're talking about here today even. So
Terrific. I think that's all I see. I think you can see the chat also. So with that, let me flash a couple more SBDC slides. Again, thank you so much, Jeffrey. This was really informative. And we'll post this as a recorded video for those of you out there. And I think you'll get a copy of the slides also from Julie at some point. So terrific. Thanks so much.
Oh yeah, and one more thing. I don't know if I didn't see it on our concluding slide here, but I'm going to put our Silicon Valley at uspto.gov. That's our email. I saw that my personal USPTO email was on the slide or in my bio, which that's all well and good. Feel free to contact me if you do have questions. Caveat to that is I'm just a detailee, which means my period of time with the Western Regional Office is, I think, going to be over in October. So if you do have questions, by all means, feel free to email us at that email address, siliconvalley@uspto.gov. And those questions, particularly it's about this subject matter, will find its way to myself, my colleague Kathleen, and we'll happily answer your questions.
Terrific. All right. Let me just talk a little bit about the SBDC experience. With regard to intellectual property and patents, we work with many companies, especially myself. That phase, you have an idea of what do I do? Do I run to the patent office? Do I run to an IP attorney? How do I start my business? What do I disclose? Well, how can we maybe figure out if this is valuable enough to really move forward? Because if you're going to obtain a patent. If you're gonna do it yourself, it's gonna cost you a lot of time. If you work with an attorney, it's going to cost you some dollars. So it's an investment either way. And I think you need to be judicial about what you do. We also, myself, I also deal with clients who have already received either a provisional or a patent, and they're building their business. And the intellectual property is part of the asset of that company, and they're out fundraising and or trying to build their business. And so we work in that in that area also. Typically what happens is if you're a client and you want to become a client, or you're not a client, you want to become a client, you complete a request for counseling form. You should see my slide here. This is for the Maricopa SBDC. If you're outside of the Maricopa region, you can go to your local SBDC. Usually there's an initial counseling session. We get to know you. We identify some goals. We figure out what's the best place to start, where we can help you. And then there are following on the sessions, and we'll, cadences every month or two. We meet with our clients and check in on them and look at their goals and check in on progress. And then counseling is by appointment only, so you need to register, and then you'll get assigned a counselor. And typically, even when you're assigned a counselor, the counselor just assigns, we'll work a schedule to fit you in on an appointment basis. So that's the way it works. I want to thank everybody for joining us today, and have a great day, everybody. Take care.
Thank you, Lou.
You got it.